The facts say that this is the least safe, least secure, and least honest election that we have ever seen in Georgia. Here are the facts that every Georgia voter needs to know. A U.S. District Court found on October 11, 2020, that the Dominion voting system used in the November 2020 election is unverifiable to the voter and in violation of 2 Georgia statutes. There are 6 sworn affidavits of counterfeit mail-in ballots in the Fulton County election results that scale into the tens of thousands of votes. The State Farm Arena video shows at least 4 violations of Georgia election law. Approximately 43,000 DeKalb County Dropbox ballots have no chain of custody forms. TrueVote's geo-tracking research showed evidence of ballot harvesting teams driving repeatedly to drop boxes in Fulton and DeKalb counties. All 350,000 plus original in-person ballot images in Fulton are missing in violation of federal and state retention laws. All 393,000 plus original ballot images in Cobb are missing in violation of federal and state retention law. At least 17,720 certified in-person recount votes have no ballot images at all in Fulton County. 18,325 voters had vacant residential addresses, according to the United States Post Office. All are parts of nearly 2 million original ballot images from over 70 Georgia counties are missing. The failure to make a mandatory check of ballot envelope signatures to the signatures on the voter registration file resulted in a 90% drop in the absentee ballot rejection rate, allowing an extra 4,400 dubious ballots to be counted. A U.S. District Court found Secretary of State's office, quote, not credible, unquote, in an August 16, 2019 order. Those are the facts that Brad Raffensperger and the local news media don't want you to know. I'm Garland Favorito. Join us at VoterGA.org, where you can volunteer or donate to help restore election integrity in Georgia. I'm Garland Favorito, co-founder of VoterGA. Do you know anything about VoterGA?
Not much.
Voters organizing together for election, voter election something.
VoterGA.org.
Okay.
All volunteers.
Are you with the Voter Georgia? I've seen you online. I've seen you. I recognize.
Thank you to VoterGA for what you guys are doing, fighting for us in the state of Georgia.
We know that you're the man.
Voters organized for trusted election results in Georgia.
VoterGA, I love their organization. It's nonpartisan. It's a big tent for everyone. The more people that join, the more we take our state back.
Well, we know that you were honest too,
Yes.
and courageous. And these are the 2 elements in society
that people don't understand are not only cool, but essential. And you are a hero in my eyes, and we will support you, and your movement will grow because it's good.
I took the initiative. I went online, I joined, I volunteered for the ballot inspections team in Fulton County, and I said, this is out of my wheelhouse, but I got to do something. I'll go down to Fulton County. You know, I'll cross those lines. I'll do whatever it takes. But I've stayed with VoterGA. I know they're working hard. I consider myself a faithful donor because I believe in what he does, and I don't think there are too many people left in Georgia who can do what Garland Favorito does and what VoterGA does. And this is nonpartisan. It doesn't matter what candidate it is. It's our state and our country that's being destroyed.
You can see all of these things. I mean, you love it when you see it and you're like, aha, you know, hand in the cookie jar. There it is on the screen. They did it. Look, they stole it. But what happens? Who's going to do something?
Well, the first step in what we're doing is to file a demand letter against the state election board saying that we're going to sue them if they don't change their rules to make it conform to federal and state law, because federal and state law requires all election records to be held for 2 years. And the destruction, to your point, violates the law. So we're going to start with state election board, and then we may have to go after the counties individually.
I can tell you that the big lie is the big lie, and VoterGA proved it this year. Not my data.
I'm not quitting.
Neither am I.
Good.
Voters organize for trusted election results in Georgia. I think that's kind of the key word, wouldn't you say?
Sure, trust. We need to have the truth with trust.
Well, and the other thing is you need transparency. So transparency and trust will give you the truth. Would you say that?
That's right.
Help us restore election integrity in the state of Georgia by going to VoterGA.org and volunteering or donating today.
Vote again. I just can't wait till we all vote again. With pen and paper, voter ID in our hands. I can't wait till we all vote again. Let's all vote again. Those mail-in ballots should have never been. And all the dead votes coming in at 3 a.m. I can't wait till we all vote again. Let's all vote again. Like a band of patriots, we will count the right way. We're the best of fans, resisting lies and fighting for truth our way and God's way. Let's all vote again. I just can't wait till we all vote again. With pen and paper, voter ID in our hand. I can't wait till we all vote again. God bless America.
Wow. So you heard it here first. Vote early and vote often from Uncle Sam.
I'll start off with telling you a little bit about VoterGA, and then Garland will give you an update on what has transpired since our October 30th press conference, where we announced the filing of a petition with the Federal Election Assistance Commission to vacate Dominion 5.5A certification, and why it's now necessary to file an emergency federal lawsuit. Then he'll expose the false statements published by the Colorado County Clerks Association regarding forensic studies supporting the expert testimony that is the basis for our lawsuit. And then finally, we'll expose the cover-up in Colorado and how that affects Tina Peters' conviction. We'll then take some questions, and we'll start with the in-person media and then live stream media, and then go to our audiences. And we're live streaming now from several platforms, and we'll be monitoring the chats on VoterGA Rumble channel and VoterGA X channel. So if you are watching online and you have a question for Garland, please make your way to either Rumble or X and put your question in the chat. And then, as always, I'll close out with prayer for Tina Peters. So now a minute on VoterGA. We are a 501c3 nonpartisan nonprofit, and all donations are tax deductible. Garland and I are both volunteers, keeping the overhead low so that most donations can go directly to the work that we do. As you can imagine, most of our funds are spent on our 6 active lawsuits, including the federal lawsuit that you'll hear about today. We travel around Georgia to educate voters, legislators, and poll watchers, and hold national press conferences like this today. We offer free expert witness testimony both in Georgia and nationally, and you'll find us at the Georgia General Assembly every session, advocating to get rid of the machines and for other important election security legislation. And I'm happy to announce today that we have a very generous supporter who has offered to a matching donation, $3, for every $1 of donation received by January 31st of 26. So if you like what you hear today, please consider making a donation at voterga.org at the Donate tab. Now I'm honored to introduce Garland to you today. He is a career information technology professional with over 40 years of experience, and that includes 13 years of cybersecurity protection for the identities, accounts, and transactions for over 1.5 million corporate, retail, and small business online banking customers. And he also has now 25 years of voting system technology and election integrity advocacy. In 2002, Garland was the first technology professional in America to advocate against statewide implementation of a paperless electronic voting system on the grounds that it would pose a threat to the constitutional right to vote. And his claims were finally upheld 17 years later in a U.S. District Court ruling that banned Georgia's unverifiable voting system on grounds it was constitutionally deficient. So with that, I'll turn this over to Garland.
Thank you, Tamara. Tamara's going to be back to help me close out today. Before we get started, we're here to talk about our federal lawsuit. Literally today, we just a couple of hours ago have filed this lawsuit in the Southern District of the United States Federal Court here in Georgia versus the Election Assistance Commission. The intent is to vacate the Dominion certification. We're going to go through why we need to do that. But the one thing before we get started, we just want to make sure, I'm going to be talking about Dominion all day today. We understand fully that Liberty Vote has purchased Dominion, but you just can't put a sticker on the machine and think it's any different than it was before. You don't put a lipstick on a pig and expect that it's not going to be a pig anymore. So there's some issues with this machine. We're going to go through and talk about what they are. First of all, a little bit of background. How did we get here today? So this started on September 30th, 2024 in the case DeKalb GOP v. Ravensburger. That case provided expert witness, unrefuted expert witness testimony and forensics that showed that the EA certification of the Dominion Democracy 5.5A system used here in Georgia was illegitimate. In October 24th, we joined with them and the individual plaintiffs, and we submitted a petition to the Election Assistance Commission to vacate the Dominion certification and to provide interim relief. We got a nice response from the EAC that they will take this under consideration, and we appreciate the Election Assistance Commission for doing that, but they declined to offer immediate relief, and we are forced to vote on this system in 2026, which is basically leaves the Georgia voters in an untenable situation. So on December 22nd, which is today, we filed, along with the DeKalb GOP, the Chatham GOP, individual plaintiffs including Rick Armstrong out of Savannah and myself, and we filed this suit in the United States District Court. The premise, one of the premises of the suit is that it does take some time. In fairness to the EAC, it takes some time for them to vacate a certification, but they certainly do have the authority, and I'm going to quote it right here, 5 U.S.C. 505, that when an agency finds that justice so requires, it may postpone the effective date of an action that has been taken by it pending judicial review. So the EAC has full authority to move this certification out into 2027, 2028, 29, even though they've already done it, according to federal law. So this federal complaint that we filed, again, as I mentioned, we are the plaintiffs, DeKalb County GOP. Chatham has joined us, Richard Armstrong out of Savannah, and myself. The defendants are the Election Assistance Commission Executive Director and Board of Commissioners, and the relief, as I think I've previously explained, is what we are seeking there according to 5 U.S.C. 505. So just for anybody who does not know what the Election Assistance Commission is, the Election Assistance Commission basically was formed in 2002. It helps officials improve election administration. That is its mission. And it doesn't even mention anything about security. So maybe it is time to change that mission statement a little bit. We have more seats up here. Y'all are welcome to come in. So why do we want to vacate the certification? Well, the 5.5A was supposedly certified in 2019, but it doesn't meet the 2005 EAC security standards for certification. 14 years earlier, 14 years later, it cannot meet 2005 standards. We're going to talk a little more about that. The specific problems that came out in unrefuted expert witness testimony is that it lacks encryption key protection and it does not have adequate password security. That's all based on that case I'll tell you about. So the certification is essentially illegitimate. Now, as I mentioned before, the EAC is supposed to be, it certifies according to the 2005 volunteer voting system guidelines, but the encryption keys are exposed in clear plain text. So what that means is that a bad actor can retrieve the keys with a simple SQL read statement, use the standard programs to easily decrypt and change the results. Now these were standards, FIPS 142 and 112, that date all the way back to 2001 and even 1985. I'll get a little bit deeper into that. So what do 142-2 Federal Information Processing Standards actually say about encryption keys? So this is the 2001 standard on which 2005 VVSG guidelines were based. It says that plain text, secret, and private keys shall not be accessible from outside the cryptographic module to unauthorized operators. It goes on to say secret keys, private keys, and CSPs shall be protected within the cryptographic module from unauthorized disclosure, modification, and substitution. So that's the encryption key side on it. But the password design has also got numerous problems, and just a few of them. Passwords are not irreversibly hashed, and they can be decrypted. You don't want to decrypt the password and use it. You want to have it hashed so that it cannot be retrieved and then used. So hashes are irreversible, but this password, according to the testimony, is that it is encrypted and not hashed. So the other serious problem is that an admin account password is hard-coded when it's delivered, and then it's used in scripts, referenced in scripts. So this is a blatant violation of standards going all the way back to 1984, which I'll show you. I can't imagine any of you having a password that is hard-coded and you can't change it. So just think about that for a second. The password was never changed since the system was delivered, and the password is publicly known and available on T-shirts that you can buy most anywhere that you want to go now. That's I wouldn't really call that secure, would you? So the other standard that is probably important to understand is FIPS 112. That standard says that passwords shall have maximum lifetime of a year. This password has never been changed. We've had the testimony confirm that. It says that all passwords that may be included in a new system when it is delivered, transferred, or installed shall be immediately changed by the security officer. That never happened. In fact, it was designed not to, because the scripts were dependent upon the password that was delivered by the Dominion voting system personnel. So this was a known deficiency. It was known all the way back on DDS4. As you can see in this deficiency report, hard-coded passwords and hard-coded crypto keys were identified all the way back for DDS4, and this was DDS 5.5. And they now have gone on up to 5.17 and appear to have the same things. So the last time this press conference is a combination of two other ones we did, one on October 30th and the other one on January 7th. And I think on both of these press conferences, and Tamara can correct me if I'm wrong, we showed Clay Parikh hacking the voting system in 3 minutes using 6 lines of code in federal court. Now, this is not DEF CON. This is a authenticated copy of the server in Superior Court being hacked by a known voting system technical expert, a testing expert, in 3 minutes with 6 lines of code. This is a whole nother level from what you hear about all the time in DEF CON. This is the real deal. You can watch this press conference. We're not going to show it to you today because we have a lot of material to cover, but you can watch it at voterga.org events. Go to our October 30 press conference. I believe we did that again on January 7th. We did. And so you can watch that. We even give you the timing mark so you can go to it and just get right to it there, 3:30 into the press conference. So what we have here, what we've learned, and from this testimony in addition, is that the Dominion Democracy Suite system they all are designed to communicate with each other via a common shared value in an X.509 certificate. Now, there's nothing wrong with having an X.509 certificate. That is a common way to communicate, but you wouldn't want the same common shared value across all systems worldwide. That means that everybody has the same password worldwide. A common shared value is basically like having the same password. So that essentially opens the back door for you. So the voting system, we've also learned from the Mesa County forensic study number 2, which we're going to talk about in a minute, that the EMS database, EMS is the election management server, the ports, the firewall, everything down aligned with it is all set up and configured, is the term we use in the technology business, to be accessed by anyone in the world. There's no firewall rules that uses the default port. So there's a variety of problems. And then we also have learned that the SQL Server Management Studio, which is a data manipulation tool, a good tool, but it is not certified to be on a voting system at all. And it's not listed in the EAC certification, but that is resident on the system, and we know that it's resident in Colorado and other Dominion systems as well. So I'm going to grab some water here. So that is theoretical remote access. But now let's get into actual remote access. We now know from both the email discoveries and depositions that our Georgia County server, one of them, and we're the only one that's ever been forensically analyzed, were set up, maintained, and accessed by Serbian programmers in the 2020 general election. And we know that, again, they were accessed in the 2021 U.S. Senate race to correct, apparently, abnormal ballot rejections. So we're going beyond the world of academic theory into actual remote access based on discovered emails and depositions. This come from the Curling v. Ravensburger case and the Dominion v. Byrne case, Patrick Byrne, up in Michigan. You probably heard about that. Well, it doesn't quite stop there. We've shown now that the system, and the experts have shown us that it is, in fact, has a back door. And, but was the back door accessed? Well, the forensics that was conducted by Ben Cotton, and I'll tell you a little bit more about Ben in a minute, showed that when he looked at this 2020 Georgia County server that came out of Coffee County, that it was, in fact, had email internet activity. Now, I want to just restate again that Ben is doing a forensics analysis on an authenticated copy of the 2020 election server that was used to conduct the election in Coffee County, unrefuted. He found that over 3,000 EMS server files, that's Election Management System server program files, were modified after the installation in 2020, all without detection. The system also had an uncertified compiler that would allow malware to be created and spread to all components. Now, a compiler accepts program instructions in English from a programmer. It converts it into machine code, and then that can be deployed and executed on any component. This is unheard of to be installed on an election system in any county, in any state in America, because it would allow someone with access to come in and change the software under which the elections run, and then all of this would happen undetected. You cannot detect it. So that's what Ben found in Georgia. We want to just show you that everything that's been found in Georgia has been corroborated in other states. In Arizona, Ben Cotton performed a forensic evaluation out there, and he found that the server in Maricopa had an unapproved dual hard drive setup, a dual boot configuration, essentially two systems in one, and the second system had non-election data and non-Arizona data on it. If I recall, I think that data came from South Carolina. What was it doing on the Arizona Maricopa election server? And it had nothing to do with elections. How did it get there? Every official in Maricopa deserves to answer that question for us. He found there 85,000 election files were deleted, 855 directories, deleted from October the 28th of 2020 to November 5th of 2020. You remember that election was conducted on November 3rd. Clear violation of federal law. Internet history found in EMS server, client workstations, and adjudication workstations all had internet history. Remember, haven't the election officials and the vendors told us for years, and maybe even decades, that these systems are not connected to the internet? Oh, well, the only forensics, the servers on the only ones that have been evaluated forensically have all found internet connectivity. They lied to us. It's now proven. We've brought the receipts. This is unrefuted expert witness testimony and forensics analysis. This is not anybody's opinion. In Michigan, Mr. Cotton's affidavit found that the Dominion election management server there had internet connectivity footprint from the Ministry of Education in Taiwan and a German cloud provider, a cloud service provider. So here we have proof of remote foreign access into the system. They didn't really want to tell us that either, did they? So at least one of the Dominion ICXs were actively used for remote access, and the invoices and emails, all this other documentation from this court case of Bailey v. Antrim, all found that they were actually transferring data remotely while denying it to us. Now let's move to Colorado. As y'all know, Colorado is going to be, we're going to talk a little bit about that. This is becoming the epicenter of election corruption in America. The Mesa County election management server was configured to be accessed from separate non-Dominion computers with only password authentication. That came out of Mesa County Forensic Report 2. I'm going to show you that was Doug Gould. We'll talk a little bit more about his credentials in a second. I mentioned that the firewall rules were unrestricted. And we found this in Colorado. 35 wireless devices were installed, all with internet connectivity, and this is just one county. 35 wireless devices were forensically found, all with internet connectivity, and they told us that they don't connect to the internet. They lied. You can see that we have a national security crisis here. Any person using a cell phone could wirelessly connect to the EMS network and change calculated vote totals. Some of you might remember we had Mark Cook here. He demonstrated that for those of you who are involved with VoterGA. And in addition, it's in the report, and they go through step by step with illustrations. So you don't have to read all the technical garbage. You can see it with your own eyes in a picture. Thousands of files were deleted during the upgrade despite federal, state, and retention laws. We're going to talk more about that in a minute. So who put out all of these forensic reports? Are these just some surfer guys, dudes off the street like the Colorado court tried to tell us? No. Let's look at them. Ben Cotton, who I mentioned, was involved in the Maricopa, Antrim County, and Coffee County servers. Highly credentialed, 30-year cyber forensic expert. He has numerous certifications. It took him 30 minutes. They went through all of his qualifications before he was qualified as an expert. He listed all of his qualifications in the September 30th, 2024, and it was astounding, absolutely astounding. Clay Parikh, who I mentioned, these two came out of the DeKalb case. Clay is a 20-year career specialist in cybersecurity evaluation. He is a voting system tester. He worked in the test labs for testing voting systems in Huntsville, Alabama, and he has tested 7 different voting systems, probably equally as more as anyone in the country. Doug Gould did the Mesa County 2 report, 40-year cybersecurity expert, chief cybersecurity strategist for AT&T for 30 years, and now he's the chief technical officer of his own cyber team, U.S. Fund. Then we have Walter Doherty, who did Mesa County's 1, 3, and 4 reports, which we'll talk about, 35-year Texas A&M professor and senior lecturer emeritus in the Department of Computer Science and Engineering. Then finally we have Jeff O'Donnell, 40-year software database developer, analyst, consultant. He's the CIO of an Ortis Analytics Services and a University Pitt computer science major. I mean, look, I've been doing cyber protection for 14 years. I have a 40-year career, 25 years in elections. And these guys are most of them are at another level from what I am at in terms of cyber forensics. So these are some of the most impeccable credentialed experts in the entire country, and they have produced some reports. So I decided, has anybody tried to refute any of these reports? And I thought I would check around, and of course no one has tried to refute anything that we have said today from Clay or Ben Cotton, anything that our lawsuit has been based on has not been refuted in court. However, I did find that there was a group called the Colorado County Clerks Association that did attempt to refute the Mesa County reports, and we want to tell you about this today because it's fascinating as we decided to kind of check into this. So they published an unsigned, undated, 4-page rebuttal in an 8-page memo referencing unspecified experts that had rebutted these 3 guys. Well, these 3 guys produced 321 pages in 4 forensic studies, have over 100 total years of experience in information technology, data analytics, and cyber forensics, and the Colorado County Clerks Association attempted to rebut that with a 4-page, unsigned, undated memo referencing experts. I don't think so. So that led me to my next question. I thought, well, what is the Colorado County Clerks Association? I checked it out. It's a non-governmental private entity. It provides certain types of election support to Colorado clerks. This is a private entity. It's funded primarily by county clerk taxpayer money and vendors. Does anybody see the problem with that? I think so. Here is the state of Colorado relying on a private entity, and by the way, this is we found out is a partisan private entity, no matter what they say. But this is incredible. Can you imagine the state of Colorado relying on a private entity to support their Colorado County clerks? It's worse than what you think, though. We're going to get there. So we filed an open records request for this rebuttal. We wanted to see if they're representing the county clerk's office, all the county clerks in Colorado. I was wondering, it crossed my mind, would all of the 64 county clerks agree with what I just said? Would the 64 county clerks agree to sign on to a 4-page rebuttal specifying unspecified experts, unsigned, undated, and attack 321 pages of 4 forensic studies by experts who have over 100 years of experience? I thought, would the county clerks sign on to this? All of the county clerks must have signed on to this, right? It's coming from the County Clerks Association of Colorado, right? So we filed, thanks to we have a wonderful admin named Tanya Salsa, who I could talk all day about, but unfortunately we don't have time, on we filed an electronic copy of any email we filed for this. Colorado has what we call Open Records Act, CORA. So we wanted an electronic copy of any email or other written communication from you or the county, and you being the county clerk. This was sent to all 64 county clerks. From you or the county indicating the county's agreement with, consent for, approval, disapproval, or objection to, or any other opinion regarding the October 25 analysis of the Mesa County Forensic Study. Because if the Colorado County Clerks Association is publishing it as though the Colorado clerks have bought into it, then they should have signed off on it, right? Well, we also noticed that on their website they had an Arapahoe County study, which was done by, I believe, Walter Daugherty there, I told you about. So we asked for the same thing for that study, and we asked for the same thing for the letter that they sent. They happened to send a letter to Governor Polis about Tina Peters. We'll get there in a second. So I wanted to see what the response was. Well, we got good responses out of most of the clerks, but the responses are going to be quite interesting to see. However, we have yet to do, as of this press conference, we have yet to get a response from anyone on the CCCA board. The county clerks in Colorado have not responded to us, and this is the board. We did get a response from one of them, the vice president, but she hasn't answered the question yet. So none of the board of CCCA has answered our question. However, the other clerks in Colorado certainly did answer our question, and here's what we found out. 1, not a single clerk in Colorado signed off on the Mesa forensic report analysis that CCCA did. Not one of 64. 0. There is no written communications, 0 written communications of anyone in Colorado in a clerk's position signing off on the Mesa County rebuttal. I use that term loosely. We also found 0 county clerks that signed off on the Arapahoe County rebuttal, which was prepared by Dr. Daugherty, the 35-year Texas A&M professor and emeritus in the computer science department there. And we found out that no one signed off on the letter that was sent to Governor Polis about Tina Peters, although we did find 6 clerks who verbally went on record as, I think, and 1 written that signed off on that. But so we've got big goose eggs really for all 3, but in particular the first 2. So let me explain a little bit more about this report and why none of the clerks would have signed off on it. So the rebuttal, I'll call it, they don't even call it that, but that's what it was, of Mesa Forensics report. Now, I could talk about this for half an hour or an hour, but I'm just going to give you one example of each report. The CCA said that operating system logs are not election records. Hogwash. Operating system logs contain the events that transpire during an election. These logs are critical to detect intrusions into the system from foreign actors or bad domestic actors or maybe even legitimate actors. They are what helps you detect an unauthorized intrusion. Operating system logs are essential in that. And the reports concluded that the trusted bill deleted these logs and all previous election projects. So Dr. Daugherty, no, I'm sorry, this one is Doug Gould, concluded that it happened, and yet they're trying to claim that it's no problem because they're not election records. Well, they are election records, and they are required to be preserved for 22 months under 52 USC 20701. Now, if you go and read that statute, you will see that 20701 has no exceptions. There's no exceptions for operating system logs. Logs are part of the election records. They're not the software. It's important to understand, they're not the software, the programs that run them, but they track the actual events that occurred during the election. That's what a log is for the untrained. Mesa Forensics Report 2, I'm just going to give you one example. The rebuttal said that the Wi-Fi capability was disabled and verified in the BIOS firmware during the trusted build. Well, we have people in this room that know that's not true, but so what is true? The trusted build is and by the way, let's clarify this, it's not trusted at all, but it's a Dominion voting system upgrade. And the Dominion voting system upgrade has proven to be untrustworthy for the reasons that I just said. It deleted the files, the audit logs, and the election projects off of the system. And it should not have done that. And it deleted lots of other things too, but that's a different story for a different day. So the trusted build, when you're making this upgrade, it has no way to verify if the Wi-Fi capability was enabled during the election. It doesn't. There's no history of whether that Wi-Fi capability can be turned on or off, because it can be turned on and off with software. It can be programmatically turned on. So again, another hogwash. Mesa Report 3. Mesa Report 3. The extra databases, it says, which were found, were created by human action when the elections manager attempted troubleshooting during adjudication. So these new databases just popped up, and the report, Mesa Report 3, said, well, you know, they shouldn't have been there. And yet this report from CCCA says that the new database was a normal function of the voting system. Well, and that's not true. A new database should never be created by human action in the normal course of a voting system. What a user does when they are using an application of any kind is they add, delete, modify data in the databases that are created systematically as part of preparation for an election. So the databases are created ahead of time. Once they go out, then they are updated with election results throughout the night and so on and so on. So as you can see here, this complete rebuttal that we have is a joke. It's 4 pages. No expert that we know of signed it. No county clerk signed it. It was unsigned, undated. So who created this garbage? I'm sure everyone would like to know. Well, we found out it's the CCCA Executive Director, Matt Crane. Matt Crane is a 22-year elections guy, but he happens to be wedded to a former 18-year Dominion Sequoia product specialist. What a coincidence that he would be supporting Dominion when his wife spent so many years there, 18-year career, that's a pretty long time. So now you're starting to see the nepotism that is involving Dominion, and you're going to see a little bit more about that in a minute. But so what is this guy's expertise? Maybe Matt Crane is smarter than all of us, right? Oh, well, let's see. He wrote a letter to Colorado legislators. And in this letter, 3 times, he referred to the Microsoft SQL Server Studio, which is Structured Query Language Studio, as SQL, S-E-Q-U-E-L. He did not know the difference between a data manipulation project and a movie sequel. That is how bad this is. And yet he put this out under the guise of it representing the Colorado County elections officials. Unbelievable. But he didn't stop there. So after he did this 4-page report, actually it was an 8-page report, 4 of the pages talked about Mesa County. And then he goes into this rant about Tina Peters. Well, the report was about Mesa County. But he decided that he wanted to go into Tina Peters, so okay, well, let's check out what did he say about Tina Peters. So, and this is where I think I'm going to ask Tamara to come back up and help us walk through this last part. As y'all know, Tina Peters had no criminal record. She was imprisoned during an appeal for a conviction of victimless crimes, and that was involving observation of a Dominion voting system upgrade. Why wouldn't a Dominion voting system upgrade be publicly observable? It is here in Georgia. What is the state of Colorado covering up, and how does that affect every voter in America? After all, with the Colorado's votes are corrupted, it can dilute votes from all the rest of us around the country. So it seems to me that we have a national security crisis, and the epicenter of that is in the state of Colorado.
And I think that's why the state of Colorado is trying so hard to keep Tina Peters in prison. Now, often you hear it mentioned, we've said it in our press conferences, she's a 70-year-old cancer survivor, Gold Star mom, and has no prior criminal record. But the truth, all that's true. She's a grandmom, she's older, and she's quite sick, in prison right now. But the truth is, this would be terribly unfair if she were 35 and very healthy. She was railroaded.
And we're going to explain a little bit about how she was railroaded. But before we get there, let me just give one example of something that, as he went on and on about Tina Peters, but one thing that he mentioned that I'd like to focus in on. As y'all know, Tina Peters has been pardoned. And he, as well as the governor, told the legislators, and I believe he also wrote this in the document, that the President of the United States has no power to pardon or otherwise, I think, commute her sentence. He has no power to pardon. Well, it seems to me that Mr. Crane, not only does he not know the difference between a data manipulation tool and a movie, but he also doesn't seem to know the Constitution. Let's look at the Constitution and see what it says about pardons. Article 2, Section 2 says that the President shall have the power to grant reprieves and pardons for offenses against the United States except in cases of impeachment. There is only one restriction on pardons of that are convicted, of those who are convicted. Now, people are trying to say that the word "the United States" there, and they go into this long ordeal about that. You have to understand something. The Constitution, when the Constitution was drafted, there was no "the United States." The states created the federal government, and the federal government did not create the states. And that might be far-fetched for Mr. Crane to understand, but that's just the way American history is. So pardons cannot be unconstitutionally prohibited for state offenses. A pardon is a pardon is a pardon, and Tina Peters needs to be out of jail right now because this is what the Constitution says, and the Constitution is the supreme law of America. So she was railroaded, and you mentioned it.
She really was. And we just want to list some of the things that went on before and during her trial. She was denied bail, although she was really overqualified. And what we mean by that is these were victimless crimes, even though they weren't really crimes, and she had no prior criminal record. She actually didn't even have a speeding ticket.
And her case was on appeal.
Right.
So this is an unprecedented in American history for these three things. That her case was on appeal, it was victimless crimes, and she had no criminal record.
Right.
Unprecedented. Show me, maybe Mr. Crane can show me somewhere in American history where this has happened before.
Yeah. And during the trial and leading up to the trial, the judge denied 41 motions made in her defense. Yes, 41. It's incredible. He also refused to allow her the best defense until her sentencing hearing. She actually tried to defend herself in her sentencing hearing, because when you have a criminal indictment, the indictee has to be allowed to put on their best defense. The prosecution took 6 days to present their case against her, and she had 1 day. There's no way that was her best defense.
And she had to end up presenting her evidence after she was sentenced, just before she was sentenced and at her sentence hearing. Right. This is an absurd travesty of justice.
Was it one judge that did all of this?
It was a jury trial, but it was one judge.
The judge prevented the evidence, and we'll get to questions in just a second.
Yeah. So she had the right to testify in her own behalf at her trial, but the judge ruled that he would not limit the cross-examination of her testimony to her testimony. And therefore she knew, and her defense attorneys knew, they couldn't take the chance of her testifying and then just bringing in all kinds of defaming evidence. It's atrocious.
Yeah, there were 700 articles, negative articles written about her.
Yeah, and
most of which were false.
And they've continued, especially since the president's pardon. The media in Colorado has just really been fired back up against her. It's unbelievable. As Garland often reminds us, we're in a spiritual war, and that's what's going on here. The county DA made false charges against her of her recording a federal court proceeding. It was actually overturned on appeal, but the temporary conviction was active during her sentencing, so the judge could say she had a prior conviction. But then right after she was sentenced and sent to jail, it was overturned.
So the DA, no sense. Yeah, thank you. So the DA basically said that she had recorded during the hearing. Then he said later, well, you don't know if she did or not, backed off of it. But this shows a conspiracy between the DA and the judge, because the judge could have never imposed such a ridiculous sentence if they had not had this temporary conviction set up in order to justify that kind of a sentence. And that was collusion of an epic, what I would consider to be a criminal activity.
And you might remember, if you follow her case, that several times over the last 6 months, she has been concerned for her own safety, and she has been requesting to go into a safe unit at the prison, which is a place where prisoners that need to be kept out of general population can go, but they still have privileges of cell phone, texting, and not being locked up. Every time she has complained about it, she ends up in solitary confinement. In fact, she just got out last Friday from 15 days in solitary confinement. She was there for her safety, they say.
So just to wrap everything up for today, we just have another slide or two. We believe that there's possible federal offenses here, and that need to be investigated. So we're going to call on the DOJ, Homeland Security, DNI, and even the Department of Defense, if we have to try to get some resolution on these things. Let me just give you, we know, for example, absolute fact that 20701 and the elections records are required to be retained. We know, I showed you the evidence that, Mr. Crane is saying that they're not. That's, you've got probably 6 expert witnesses with 200 years of experience willing to say that they are. And so I don't know how that's going to hold up. But this appears to be a violation of 18 U.S.C. 2A, aiding and abetting the covering up of the election record destruction. Also, you've got 18 USC 371. There appears to be some type of a conspiracy here that is allowing this to happen. And you've got the guy who is wedded into Dominion, who is then making up all this stuff and telling everybody that Dominion is okay. He's told, we've got the letter to every legislator in Colorado where he's made these statements. It's beyond belief. And then he puts this out. First of all, the conspiracy charge also is 241, but he puts this out under the color of authority of the CCCA, the Colorado County Clerks Association. So that could be another potential violation of 18 USC 242, and there could be even more. We're just saying that this warrants an investigation because it appears to us that a some criminal activity may have occurred here. And then finally, so we just want to leave you for this before we open it up for questions. This is the epicenter of corruption here. Colorado is linked to Georgia through the Dominion voting system. And all of this massive cover-up that is going into Colorado could basically dilute the votes of Georgia, just as we saw in Fulton County and a dilution of votes in the 2020 election that impacted the federal election nationally and the electors. So bottom line is the cover-up in Colorado is fueling a national election security crisis. And we want this election security crisis to be resolved before the 2026 primaries, which in Georgia occur in May. And we are asking for the president to step up and now that he's gotten his some of the foreign affairs tamed down, it's time that we focus full time on election security for the 2026 election and get these problems resolved. It's going to require a national effort coming from him and from Congress. So we are asking for federal action all the way around on this. Amen. And that said, yeah, I think we'll take questions. Do you want to double check the chat? Or?
I will. If you are media watching online, please identify yourself in the chat and we'll take your questions. And then our in-person audience, please wait for a microphone. So we want to make sure your question is heard on the live stream. Okay.
And we do have media in the room, so we'll start with y'all if you would like to ask any questions. I do want to mention that we have, if you like what we heard today, we have that 3X matching donation. That's a real thing. A very generous donor has stepped up and offered that between now and the next 30 days or so. Do we have any questions here in the media? And if not, we'll go and double check media on the social media, and then we're going to open it up for the room questions as well.
Okay.
And we can blend them in if we don't have any set up already.
Okay. I've got one here. It says, if the certification for Dominion is vacated, will this overturn the use of Dominion in other states that use them? Which is a great question.
What a great question. And did I miss that slide? I had that slide in here. Maybe I accidentally missed it. So what we know is that based on the expert witness testimony, the problems that we have described with the Dominion system exist in all of the Dominion 5 series products. And those are used in many, many states. Many of the voters in these states are aware of that, and they have already submitted EAC petitions to vacate the Dominion certification in their states. And I believe petitions have been filed from California, Arizona, Pennsylvania, Michigan, Wisconsin, Florida, and there's probably a couple more that I'm missing. So yes, now this particular lawsuit will be only for the Dominion 5.5A. However, if this is upheld, the EAC, I think, will be compelled to vacate all the other remaining Dominion certifications as well, but that remains to be seen.
A related question is, if Smartmatic is really the root of all of the software, is there a way to go after Smartmatic?
Well, that is the relationship. So what we know there is that Dominion was Dominion acquired Smartmatic. Well, let me back up. They acquired Sequoia. Smartmatic acquired Sequoia in 2005. Sequoia was the original Colorado voting system company. And it had about close to a third or fourth of the market. Smartmatic acquired that in 2005, that was when they brought in Eric Coomer. And then in 2010, Dominion acquired the Sequoia portion of that, or U.S. market, from Smartmatic. This does not really directly impact Smartmatic. However, you may know that Smartmatic officials and Smartmatic as a company have already been indicted by the Department of Justice for what appears to be very good cause.
Okay. And another question is, can you speak to where you filed the lawsuit?
Yes, I apologize. Another thing I missed. The United States Southern District Court, and we filed in the Savannah Division down there. So that's where the case will be adjudicated.
And also, it'll be later this afternoon before the case number is available. We filed this morning, and it takes them a few hours, so we'll have the case number later today.
That's right. The case will be later today, but the complaint is already up on the VoterGA.org legal tab. We got that up just before we came over. You can see the complaint. That will be followed up with a motion. That motion will have my declaration in it and several others. It would be an interesting read. If you want to read something interesting, just read my declaration.
Okay, I think that's it for the live stream. You want to take in-person?
Absolutely. So we'll start with in-person questions. We've got a couple up front here. And Cheryl's going to bring you the mic. And then we will, I think it was Ben and John, right? Go ahead.
Hey Garland, Ben Hendrick. I'm a cybersecurity expert and volunteer. In lieu to the new discussion that happened on Friday about the 315,000 ballots, right? The word sign on the register tapes. How does that play into the order that you have that we're supposed to be able to examine the physical ballots, right? Mail-in ballots for Fulton County, and they've been stalling on this for, I don't know, what, 5 years?
Right.
How does this all come together? And we really need to look and see what they've been hiding. Okay,
great question, Ben. Thank you for. I know you know this material better than I do. So this is a great question. In fact, we have the gentleman in the room who is responsible for that case. There's several things here. There's a lot of things, and the first thing, a couple points. In order to verify election results, you have to have ballots. They have to be transparent. In Colorado, no one has ever seen the public has never seen the ballots because the ballots are not publicly available in Colorado. So they've been conducting elections on this Dominion system, and members of the public can never verify the results. They're telling the voters in Colorado that everything's okay, and they'll be okay. Now, we had the same problem in Georgia. But we worked hard. Tamara and I were down there in the legislature. We worked. It took us 4 years to get ballots public record here in Georgia. That was quite an accomplishment. It wasn't easy. And then now they still want $49,000 sometimes for the ballots. But we have been able to work a deal with a couple of counties to get them. But the other point is, now even though this case we found that David has found 315,000 missing tabulated tapes, 148 tabulated tapes, and missing 0 tapes as well, impacting 315,000 ballots. That is a huge, huge case. It was deferred for the Attorney General for criminal prosecution up to $1.4 million of possible fines. But the other interesting thing is, and I'm sure David can tell you about this, but there is more cases that are going to come out. And these cases, in fact, I think at the next meeting, the board is going to talk about the SEB 2023-025 case. But these cases are showing electronic manipulation of the Fulton County 2020 results. They are showing, one of the complaints shows that first of all, that there were many duplicate scanned ballots, but one of the most interesting things is that the Fulton County appears to have backfilled the results to make everything match up on December 4th. And that indicates to me electronic manipulation. So that's how all that plays in together, even though it doesn't appear to be directly connected. But in this case, I think it really is, Ben. So thank you for that question. I think, John, did you have one?
John Evans, we're talking about certification. Now, most of the software that I have is on subscription, and it's got a link on it that says, check for an upgrade, or it automatically does that. Now, if the Dominion system that was certified had one letter or one number change, in some way of upgrading or just changed because it's connected to the internet, how would that affect certification?
Great question. Great question. So the certification, there is something, here's the way they get around this. They have something called de minimis changes. And the de minimis change is something that they say, well, this is just really small, it's a configuration change, and therefore we don't need to recertify. And there is some truth to that. There are certain things you don't need to recertify. But when you go in and you find that 3,000 program files were modified, like it was on the Coffee County server, there is no way in heck that that is a de minimis change. So that should have been certified. Great question. I think we got one in David, and we got one in the back here. I think David got one, and then we go to the back. Okay. Or we do it vice versa. Okay, we'll get over there. Yeah.
Malkins. Can the president send the U.S. Marshals in to get Tina Peters? I mean, it seems.
There's a lot of. I think I'm not going to probably be able to comment on that one. But there's a lot of concern. You know, how long is Colorado going to keep Tina Peters in prison in violation of the United States Constitution? Colorado is imprisoning Tina Peters in violation of the United States Constitution. All you got to do is read it. But
can someone be held accountable for that in Colorado? Would it be the warden or the governor?
Well, so the warden has the control, and the warden was appointed by the governor. Moses Andre Stancil in 2023 was appointed by the governor, Polis. He has the ultimate authority. Of course, he's going to probably do what Polis says, but it really comes down to him. The mandamus is against him, not against the governor.
And my other question is this where Mike Lindell's legal battles are? Aren't they in Colorado over the election integrity?
He had one legal battle in Colorado, and I think he's got one or two more that are still active. I think David had a question up here, and we'll get over to Larry Garland.
Thank you, Garland. I appreciate your tireless efforts on doing everything to continue giving this thing oxygen.
Likewise, you've been doing it too.
Well, thank you. My question is, let's assume that the lawsuit is successful. The pushback that I think we're going to hear from politicians is going to be, oh, you can't change the election system in the same year, but we know that happened in 2019. So I guess the question, two questions is one, do they have to act under like emergency authority to do something if it is overturned? And number two, it seems like we've been consistently hit with judges that don't want to make decisions, delay. Do you have any sense of how soon this case may be heard and what the timeline may be?
So these are great questions, and it's funny that you mentioned this question. because we anticipated that, exactly what you're saying. So just this morning, I changed my declaration, and if you go to read it in the last paragraph, it explains that in 2002, Georgia went from 3 disparate systems to this complicated, unverifiable paperless system, electronic system, in 6 months flat. So, right, the DBOL system. So if they did that in 6 months, they certainly could go from this complicated, incredible mess back to a simple hand-marked paper ballots, publicly recorded hand count system in half that time. So we do have time. And I wrote that in my declaration. It's on the very last paragraph, just literally this morning, and got that in, and that will be filed this afternoon in the motion. But to the other part of your question is, what will the judges do? Will they act fast? So, and it's a great question. I don't know. What I can tell you is that when we filed the Fulton County ballot case that Ben was talking about, on December 23, 2020, we had a hearing by January the 6th, because in January 6th, when there were all the activities going on in D.C., we were sitting there and prosecuting our case remotely, and Fulton County got scared and they decided to pack up and go home in the middle of our case. And we had to wait an hour or two for everybody to get back home and get back online. So I say that, but to say that they can move fast. That took 2 weeks for us to get our first hearing, and we can get it. It can be done. It just depends on what they're willing to do that fast. And all we can do is do it and hope for the best. Any other questions? Okay, we've got a couple more.
I've got an interesting question about Fulton. If they've admitted that the 315,000 ballots from the unsigned tabulator tapes are not certifiable, then what about all the tabulator tapes that were signed under the Canadian law?
Well, wow.
I know.
That's a good question. So they were unsigned or missing, yes.
Right,
Either
but they had to agree that that was a problem.
Yeah, well, they agreed that they were missing and unsigned, but they would probably not be willing to take the extra step.
And say that they were uncertified.
And say that they were uncertified.
Okay.
However, to your point, they were uncertified. I mean, if they're not signed, they're not legitimately certified election. And there's hardly any dispute about this, but they just didn't want to say that. But yeah, they are. So here's the question. This is a really incredible question. I wish I had the other presentation. We have this, if you go back to our January 7th presentation. For all of you watching nationally, this is really important if you have a Dominion voting system. The tabulators tapes that the poll workers sign are signed according to the local Elections Act.
Election Authority Act.
The Local Election Authority Act. That is what the poll worker is signing oath to. If you go and look on and find out what that is, and we told you this in January 7th, thanks to some of our supporters, Mr. Metz and Sarah Thompson and all these, and quite a few. But if you go and look at that, it is a Canadian law. And it doesn't say the Local Election Authority Act. It doesn't say a local election. It says the Local Election Authority Act. It is a Canadian law. So the poll workers are signing an oath to a Canadian law. Remember, Dominion is a Canadian system. Dominion is owned and operated by a foreign entity. They are a Canadian company, so the question is, does that invalidate every single election that has ever been conducted on a Dominion system? I don't know the answer to that question, but I think somebody should bring that evidence forward and file a case to vacate virtually every election that's ever been conducted on a Dominion voting system, because they should have been sworn to our laws, not to Canada's laws.
Okay, one more. Looks like we could keep going all day. The Georgia code requires that the electronic voting system be certified by the Election Assistance Commission, correct?
That's right.
So that would mean then that if we get the EAC to vacate the certification, then Georgia's stuck.
That's right. So if the EAC vacates the certification, as they have to do, they are going to be compelled to do this based on the evidence, or they're going to have to find another judge who won't rule according to the facts and the law. We've seen a lot of them. But once that happens, yes, that will mean that it's invalidated here in Georgia because the Secretary of State has to certify this as safe for use here in Georgia. And the judge let him off the hook here in Georgia as Fulton County Superior Court judge, and that's another long story, but they let him off the hook claiming, well, he had the certification back, even though it's obviously not safe for use, it is required by Georgia law. The judge ruled that, just because he had a paper certification from 2019, that everything was okay, literally. That's Judge McAfee. So so we're just going and fix it at the EAC level. If you want to play that game, it will get a better, more honest ruling out of a federal court than we will ever get in the state of Georgia.
Want to take one more?
Yeah, sure.
Okay, this has to do with, is there criminal activity? Somebody asked, if listening to these MESA reports and the analysis of Colorado, it sounds like we've got a bunch of inept programmers and analysts, but is that really the case, or do you believe that there's criminal intent?
Yeah, so the question is, did all of this just happen by accident? Or do we have all these incompetent people in all around in all these voting system vendors? Or was there something more sinister there? I think that you in the room have already answered that question, I can tell. But the problem is, I'll give you an example. As y'all know, the Dominion Democracy Suite 5.5 system and the ES&S system, Express Vote, they use a QR code to embed and hide the votes from the voter in the QR code, and then they tabulate the results out of the QR code and they show the voter something different. Now, obviously that's unverifiable. They come out with this system in late 2018, 1920, and we have been arguing that a voting system has to be verifiable for 15 years. So why would voting system vendors, two of them, the two leading vendors, come out with a new wave of unverifiable voting systems 15 years after they were since they've been getting beat up about having an unverifiable system 2002? That is beyond incompetence. That, to me, indicates that there was some type of criminal intent in bringing these systems to market. And they've created a national security crisis with remote access. We've shown you just a little bit today. There's much more about foreign access. And this has got to be resolved by the 2026 primaries. We're asking the president to act. We're asking Congress to act, because it's obviously we're not going to get relief from states like Georgia and Colorado and Arizona.
Okay.
Can I make a statement?
We just have, it's got to be a question.
Okay.
Has to be a question. Okay.
Say it in the form of a question.
Yeah, yeah.
Okay, I'll ask the question.
Okay, it's got to be related to this.
Hello, my name's Terry Sweeney,
Yeah.
Forsyth County.
Yeah.
How come nobody has brought this to anybody's attention? It says Supreme Court upholds legislation on photo ID requirements for voting. This
Okay.
was in 2007. I think it would be a good idea to have the people out there, not that this is out there in the public and here.
Okay.
Can anybody bring this to somebody's attention at any time?
Well, we can talk about that offline because it's not related to this.
Okay.
This stuff.
As long as we got it out.
So, Matt, you had a question? Yeah. Okay.
Thank you for everything you do. My name's Matt Stout. I'm a volunteer advocate since Stop the Steal way back when, and I was former President Trump's field representative to the state of Georgia in 2015. Can you talk for just a second about the state election board and their ability and what they've done to reveal some of the information and some of the things that we've been able to see? You haven't really hit that note yet today, and I think it would be good for people to hear about it.
Thank you. Well, this is a national press conference, so we haven't focused much on Georgia at all, but that is an important point, because one of the reasons why David and others have started to be successful is because the state election board has been reconfigured here in Georgia. And I mentioned this morning, I think, on Bannon. But so the state election board now has a majority of people who really care about election integrity. And they, when they're presented with the evidence, they're willing to make the right decision. And they were impeded by members and even the chairman, quite frankly, who seems to have disappeared now. But now that we have a good state election board, I think that you're going to see a lot more cases come out, and it's going to be even more amazing than what David has already done, because I know David has got quite a few lined up. I might have a couple of myself, but I never wanted to go through the SEB because it was so corrupted. But with this reconfiguration, you see, David stuck with it. With the reconfiguration, now you can get legitimate cases and legitimate solutions made. So I gave up, and this is the power of having volunteers just stick with something like a dog with a bone until they get it. People say, I do that, but that was David and Joe Rossi and some of the others who have done that.
Do you think that Sally Grubb would make a good board member for the state election board?
I can't get into anything like that here because this is a national press conference. Okay, so we can take that offline, and I will answer that. So anyway, I guess that wraps it up.
Yeah, we're going to pray for Tina.
Okay, Ben. Oh yeah, we're going to end with a prayer for Tina, and Ben is going to get the last question on that.
Yeah, Garland, I felt kind of an insight, right, just to make this comment, right, in terms of would it be helpful if I provided to you all evidence that was submitted to the Department of Homeland Security of those voting registers from Dominion voting systems that they're missing. I have obtained those through a confidential source. It is on file with the Department of Homeland Security's evidence. I have an active FOIA to receive those, and I have all that here on my phone. So I would like to be able to share those details with you all if it would help you as part of your case to move things forward.
Ben, we were happy to.
And our friend Tom Feehan is the one that ordered them to be shredded, but these didn't get shredded.
Very good.
Tom Feehan is works with Dominion, or at least used to. So we're going to close in a prayer for Tina because she's an American political prisoner. Yeah. And thank you for that, Ben. We will accept any evidence that you have and see what we can do with it. That said, Tamara's going to close us out. I want to just remember one last thing before we pray. Tina needs your help. Also, we do too. We do have that 3X match running from January and
through January 31st.
Until January. And then Tina needs help too, and we'll tell you how to do that.
Right. Yes. If you want to follow Tina, go to tinapeters.us, and that's where you can donate to her, both to her legal fees and to her personal expenses. And I just want to give you one quick update. I mentioned that as of Friday, she was let out of solitary after 15 days. And when she came out, the other inmates, they cheered and they danced and they thanked her because she had brought to the attention of the DOJ the conditions of the prison, how horrible they were, and they've had investigators in there and they're cleaning it up. So they were so appreciative. So she now has the inmates on her side, which praise God for that. So let's pray. Father, as we come to Tina's second Christmas in prison, I just want to say, we know you are a good God. No matter what circumstances sometimes look like here on earth, we know you are good, and we thank you for what you have done for us. We thank you for Jesus and what he has done for us when he died on that cross and rose again. And Lord, I thank you that you are holding Tina in the palm of your hand, that you are protecting her. And I thank you for the angels that surround her in that prison to protect her. And I thank you for using her right where she is. But Lord, we're asking now that you accelerate her release, that you open these prison doors to her just like you did for Peter in the Bible. You said because the people prayed, the prison doors opened. And so, Lord, we're coming to you again and asking you to move on her behalf, whether it's through Governor Polis, whether it's through the executive director of the Department of Corrections, or whether it's through President Trump. We ask for her release. In Jesus' name, amen.
Amen.
Thank you for joining us today. We'll see you in 2026.